I'm going to introduce Janice, civil rights attorney, founder and executive director of ACSOL, for her presentation, Registration is Punishment, Smith versus Doe must go.
You give me this?
Yes, you got to have that thing.
Okay, so good morning, everybody. It's so nice to see you here. I know a lot of people traveled a long way, including me, all the way from good old California. I'm certainly no stranger to Washington, D.C. I actually lived here for about 10 years myself, and I was one of those federal government attorneys. And as I tell you to many people, I have a very checkered past. So when I was a federal government attorney, I worked for Congress, gasp. I worked for NASA, it was more fun. And I also worked for the Air Force and the Pentagon, that 5-sided wind tunnel. So anyway, very close to here. And the interesting thing for me is that the work that I used to do came from my head, right? I probably have gone to more rocket launches and more space shuttle launches and landings than anybody in this room. And that was really cool. It came from my head, okay? I love geeks, I love nerds. I've got a couple daughters who are geeks and nerds, and I'm very happy about that, right? So I'm glad I inspired them. But the fact is that the work I did before did not come from my heart. And I'll tell you, the work I do now comes from my heart. So for me to represent you on the registry, family members of registrants, and those of us who support registrants comes from my heart. And because it comes from my heart, it's really easy every single day to wake up and go, wow, what do I get to do today, including being here. So I'm really blessed to be part of the planning committee for this event. By the way, just so you know, we think that this is like a dress rehearsal for next year. So look around this room. We had 76 people who signed up for the conference, 76. I hope next year it's at least 200. I expect next year it will be at least 200. If it is, we're going to basically outgrow this hotel. We can put 200 people here in chairs face this way, okay? But we have more elbow room in this environment, and I'm glad about it. So why do I say that? This is, as Chris said, this is the third year that we've had a vigil, all right? And so I was one of the people that got a brainstorm, or some people might call it a brain fart, 3 years ago, going, oh my God, the 20th anniversary of Smith versus Doe is about to take place. We need to do something. We need to do something. So we're like, oh, let's go to the Supreme Court. They're the ones who created this mistake, this disaster. We need to let them know what the heck has resulted. They have no clue. And I'll tell you how clueless they are in just a few minutes. But the fact is, trust me, they had no clue what they did, much less the consequences of what they did, because they live in their little ivory tower, right? And I'm sorry, even though they said that, believe it or not, registration is similar to applying for membership at Price Club. Price Club. You know what? I bet none of those justices ever been to Price Club. And the attorney who said that, John Roberts is his name. He's now the Chief Justice of the U.S. Supreme Court. He had no, does anybody care if I swear? Okay, here goes. No fucking clue what it was like to apply for membership in Price Club, much less to be on the registry, okay? So that's what we're dealing with here, folks. And so sometimes, I don't know about you, if you feel like Alex in Wonderland or Alice in Wonderland, I do, and I'm not even on the registry, right? So anyway, we are here to put some corrective lenses on the Supreme Court justices, and so that's what we're doing. Now, the first 2 years we did these vigils, the court was not in session. It's in session tomorrow, okay? Those justices are going to be in the building. Their staff will be in the building. They are going to be paying attention to what we do. And by the way, we sent them a letter. We sent them a letter, right? So 43 organizations came together to send them that letter. 43. Think about it. And I'll tell you, in our movement, we have a whole lot of people with strong opinions and strong personalities, and quite frankly, we don't always get along. So this is a momentous occasion that we are here and that we came together for this event, okay? It really is. And the planning committee, we thought about, well, should we invite the ACLU and the NACDL and all these other initials? We decided no, that again, this is a dress rehearsal. We don't want to invite those other much larger organizations to come join us when we don't have our act together yet. So this is our dress rehearsal to see if we can, in fact, get along, join hands, and sing Kumbaya. And by the way, that's what the Unity panel is about this afternoon, okay? So I think we can do it, okay? Please cheer us on in the Unity panel if we're all still standing. This will be a good thing. Okay, so let's go talk about Smith versus Doe. Why is this important? You guys need to know why we're doing this, right? Because the U.S. Supreme Court issues decisions on a fairly regular basis, not as many decisions as I would like them to. They don't take as many cases as I would like them to. But the fact is that you need to know the impact of this decision. And so when I created ACSOL and we started talking about, well, what the heck are we going to do? It's like, okay, we have three pillars, or we have three paths down which we travel. One of them is education. Education is really broad. And one of the things we think is really important, and I believe in completely, is we need to educate members of our community. That's why you need to know why Smith versus Doe is so important, and it's important to overturn. So believe it or not, for the next minute, I'm going to talk about tapestry, weaving, okay? Are there any weavers in the crowd? Okay, maybe you can correct me if I'm wrong. But I understand that when you weave a tapestry, there's one thread. If you pull that one thread, the whole tapestry collapses. Folks, I'm looking for that thread when it comes to the registry. It may be overturning Smith versus Doe, I don't know. And maybe that letter that we sent to Doge, whoever Doge is, Elon Musk and company, those unelected officials, government officials, okay, we don't know where it is. So we are traveling down three paths simultaneously: education, legislation, and litigation. I happen to do all three. So today I have my education hat on, but many times I have my litigation hat on. And if you ever want to compliment me, if you do, call me a badass attorney. I consider that a very high compliment. So anyway, some people don't. So let's talk about Smith versus Doe. But before I do that, I want to know who is in the audience here. How many people in the audience are actually on the registry? How many? Okay, quite a few. How many are family members of registrants? Does some of you put your hand up twice? It's possible. Okay. And how many people support registrants? Come on, Stephanie, you and I. Oh, okay. Oh, well, okay. I should have been more precise with that question. Well, anyway, hopefully we don't have any government officials in the room. If you are, please leave, okay, because we don't want you here. And I'm serious about it, okay? This is our space. And I have been asked time and time again, what about the victims? And I go, they have their own conferences. They have their own meetings. They don't belong at ours, okay? We are here for you. We are here to support you. We are here to love you. We don't judge. Tell people over and over again, I'm a judgment-free zone. And I don't know what happens in other states, but in California, when registrants are on parole, I guess every time you go to a meeting, you have to talk about what you did. So when they call me, they want to talk about what they did. I go, stop. I don't care what you did. I literally do not care what you did. Okay, let's talk about where you are today. Okay, where are you today? What challenges are you facing today? That's what we care about. That's what we're here for. ACSOL, NARSOL, all the other organizations, we're here to support you. We're here to love you because there's just not enough love in this community, just in case you haven't noticed, right? All right. Okay, so let's talk about Smith versus Doe. Oh, wait, of the people who are on the registry, how many of you have been on the registry for at least 5 years? 5 years? Okay. How about 10 years? Wow. 15? 20? Anybody been on 30 years or longer? Okay. Frank used to be, okay. But he's off the registry now. Yay, Frank! Woo! You're welcome. It only took me 3 attempts in under 3 different laws, and after only 44 years of registration, right, Frank? Yeah. So this, I mean, Frank is like exhibit A to why Smith versus Doe is so terrible, all right? Because what Smith versus Doe says is that government at every level, local, state, county, feds, they can pass new laws and apply them retroactively. So when Frank pled guilty to a sex offense in 1979, there was no internet, right? Al Gore hadn't created it yet, or whoever really did. But anyway, there was no internet. How would Frank know when he pled guilty that somebody was going to show up at his house and try to kill him in his own home for no other reason that his information, including his home address, was on a public website, right? And for those of you who have been on the registry 5 years or longer, there have been no laws passed and applied retroactively, okay? There have. Roger, where are you? Why is Chris passing on name tags? Oh, well, thank you, Chris. So, by the way, if you ever volunteer for this organization, this movement, you will be doing many things. Okay, so anyway, so this is the craziness of it. We have a bill that's now pending in California that would add 30,000 people to our registry, okay? Because if the bill passes, it's gonna make registration required for people who've never had to register before in their whole lives. They pled guilty to something, believing they were not gonna have to register, and if this bill gets passed, by the way, we defeated it once, but it came back, it's like, I don't know, Phoenix, Lazarus, whatever you believe in, that's what's gonna happen. More than 30,000 people would be added to our registry. Some states don't even have 30,000 people on the registry, but you know, California, we always do things bigger and better. So we have over 100,000 people on the registry, 100,000, okay? And I know there's some statistics out there. Some other states think they have more people than California. I don't think you do. Okay, I'm sorry to say, but we have over 100,000 people on a registry. Of 1 million people, that's a big percentage. So anyway, too many people for sure. Okay, so let's talk about Smith versus Doe. This is all about the state of Alaska and the state of Alaska's registry. At that point in time, if you lived in Alaska and to register, they sent you a letter. You filled it out, whoops, you filled it out, and you mailed it back. That was it, that was registration in Alaska. So maybe it wasn't any more onerous than applying for membership at a Prize Club, right? Maybe. But the fact is, that's not what it's like today. So I know in many states, some people have to register every 30 days. In California, if you are homeless, they call them transients, how nice. If you're homeless, you're registering every 30 days. We have, I think, over 5,000 people in California who are considered transients. So they're registering every 30 days. Makes no sense to me. Most people, though, in California only register once a year. Okay, so one of the things about the decision of Smith versus Doe, and if you ever have a few hours to spare and you need to go to sleep, read Smith versus Doe. It's actually not that exciting, the language. You read it and you go, oh yeah, well that makes sense, that makes sense. They say things like, there is no affirmative disability or restraint in registration. Think about your life. No affirmative disability restraint. They said the notification system was passive. It doesn't resemble shaming. This is in the decision. It does not resemble shaming. And oh, by the way, there were no presence or residency restrictions. That's what it was like in 2003 in Alaska. That's not what it's like today. And I don't know about you, but it makes my blood boil and makes me, I guess I have a low threshold for getting pissed off. Okay, so why did the Supreme Court say this, right? What is supposedly society all worried about? The re-offense rate. They're worried that people on the registry are gonna do it again, okay? I want to teach you something. Never say the word recidivism again. Erase that from your vocabulary, and I'll tell you why. I'll give you a really good example. In California, a registrant on parole, there's a 90% chance they're gonna go back into custody. Usually flash incarceration, 5 days, maybe 30 days, depending on how bad it is, for basically doing something that's probably legal, like a toy, okay? You're on the registry in California and you're on parole, you can't have a toy. What constitutes a toy? Yeah, Amanda, it's true. Okay, so a toy. So one of my clients went to a professional baseball game, and that day they were handing out souvenir bats. He's like, well, that's nice. Threw it in the back of his car and forgot about it. I'm dangerous, I'm Italian, I talk with my hands. Okay, so the fact is, he had a souvenir bat in the back of his car. His probation officer tried to violate him for having a toy in that souvenir bat. He's like, what the hell, it's a souvenir, it's not a toy, okay? Another one of my clients was so awful that he downloaded Angry Birds on his phone. It's a game, a lot of kids play it, but so do a lot of adults, right? And so he was an IT guy. He would be downloading software on his computer, on computers of other people, rather, at work, and he had to sit there for 20, 30 minutes while the new, the software was being downloaded, and he was bored, so he played games on his phone. One of them he played was Angry Birds. So his probation officer tried to violate him. He had been on probation for 4.5 years, had a spotless record, and that, I'm just going to use the word bitch, that bitch took him to court and was trying to send him back to prison for 5 years for having Angry Birds on his phone. And, you know, I was lucky that day because I had a senior judge who said, I don't think so. That is fucking ridiculous. He didn't use the F word, but I will, okay? So guess what? And the thing is, if he had gone back into custody, he would have lost his job. He would have lost his life, right? He was married and had a kid. His life would have been shattered if that had happened. And the probation officer really didn't give a shit. She just didn't give a shit. Oh, well, I told you, no toys, no whatever. I don't know how you consider software a toy, but she did. Anyway, again, I had a good judge that day and said, I don't think so, lady. Get out of my court. Okay, so back to Smith versus Doe. There's a sign here, right here. Okay, so one of the things that they said in the court decision is that the re-offense rate, but I think they might use that other R word, which I'm not going to repeat. Again, erase that other R word, re-offense rate was frightening and high. Okay, up to 80%, frightening and high. Well, if it were true, that would be frightening. And it would be high, but that's not the truth, okay? The truth is this. The re-offense rate for a registrant on parole in California is less than 1%. I'm not even going to tell you what percentage is because then you only think of that number. It's less than 1%. Folks, this is not Janice's personal opinion. It is in the Department of Corrections reports. And I love when I sue the bastards to basically feed them back to there and to the judge. And they're like, oh, it's frightening and high, it's frightening and high. I go, really? Less than 1%? What is frightening or high about less than 1%? You need to understand the difference between the word reoffense and that other word I'm not going to say. Reoffense rate, less than 1%. By the way, if you're on parole in California, the recidivism rate is 90%. 90%, right. Anne's got her mouth open back there. It's 90%, folks. Guess what? Because stuff that you do, remember the Angry Birds, remember the souvenir bat? Oh my God, this is perfectly legal to have a souvenir bat. It's perfectly legal to download Angry Birds on your phone, right? But it's a parole violation, or it could be a parole or probation violation. So anyway, where did that term come from? Where did up to 80% come from? A Psychology Today article. The US Supreme Court relied upon an article in Psychology Today. Now, I don't know if you all ever pick up that magazine, but I don't bother. I certainly wouldn't pay for the damn thing. It's, as far as I'm concerned, a bunch of junk. So the US Supreme Court relied upon an article in a 1968 version of Psychology Today. It was a comment made, by the way, a marketing statement made by a counselor. He said, yes, it's up to 80%, right? And he goes, but if they come to me as a counselor, I can cut it in half. It was a marketing statement. There's absolutely no basis, no research done whatsoever. It was a marketing statement. He has since retracted that statement even, okay? But guess what? The decision's there. We're all living with the decision, Smith versus Doe. Okay, so I'm gonna talk a little lawyer language here, sorry. We'll go Latin. I don't know much Latin, but this one, ex post facto. Okay, so the ex post facto clause of the Constitution, Frank, can you bring me my purse? Remember, I'm a nerd and a geek, so I carry around a copy of the Constitution. And actually, I suggest that you all do the same thing, okay? Thank you. Frank knows better than get in this purse because it's a mess. Okay, so here's my pocket Constitution, okay? Pocket Constitution. One of their clauses in there is there shall be no ex post facto laws. And what does that mean? You're not supposed to pass any laws and apply them retroactively. Why? Well, think about it. You know, I went to law school a long time ago, and when it came to criminal law, which I thought I'd never have anything to do with, anyway, criminal law, you know, it's like supposedly a person thinks before they pull the trigger and shoot somebody, they think about whether or not they're going to go to prison, okay? So supposedly, before you thought about committing a sex offense, you thought about the ramifications of it before you did what you did, okay? Remember, I'm a judgment-free zone. I really don't care what you did. Okay, so the fact is, think about it. What if a law passed? I'm always afraid of this one. It's illegal to consume caffeine. I'd be in trouble, okay? I have 2, maybe 3 cups of coffee a day, and if you deny me my caffeine, I'm gonna be grumpy. There's just no doubt about it, okay? So it's like, and so then, I mean, what if they did that and they go, okay, and I didn't start drinking coffee till I was 40, but and now it's a daily habit. I'm like, you know, Janice, you've been drinking coffee since you were 40. We've been keeping track. You've consumed this many cups of coffee in that time, we're putting you in prison now. It makes as much sense, right? They're gonna make coffee illegal. Okay, or caffeine, sorry. And those of us who drink Diet Coke, same thing. Caffeine, you caffeine junkie, you. Okay, so we just don't know. So the thing is, you're not supposed to create criminal laws after somebody's already done what they did, right? But this is exactly what's happening in Smith versus Doe. And really, it's like the U.S. Supreme Court wrote a blank check to government and said, anything you want to do is fine with us. And that's exactly what's happening. Okay, so we talk about residency restrictions, we talk about presence restrictions, where can you live, where can you visit? In California, we had presence restrictions all over the damn state, and guess what? None of them were the same. So in some places you could go to the beach, and other places you couldn't go to the beach. In some places you could take your dog to the dog park, and other places you couldn't take your dog to the dog park. And get this, there weren't any signs to warn you. Okay, so we had a man in Los Angeles County, he decided to go to a park one day. It was a beautiful spring day. We actually have them in California. Beautiful spring day, and he took his camera, and he was taking pictures of the flowers. And guess what? They arrested him for taking pictures of flowers because he wasn't supposed to be there, but there were no signs telling him of that. Well, but guess what? We've gotten rid of presence restrictions in California and residency restrictions in California. It only took 100+ lawsuits. So we have none. If you want a safe place to go, come to California. That's a commercial. Okay. One of the other things I mentioned briefly with Frank is the internet did not exist at the time that Smith versus Doe was passed, right? There was no, and they said there's no public shaming. By the way, the dissent in Smith versus Doe and Ruth Bader Ginsburg, my hero, she wrote, RBG, okay? RBG said, look, this is what's gonna happen. If we rule in favor of the government in this is what's gonna happen. She was like, had a crystal ball. She knew what was gonna happen. She knew there would be public shaming. She knew that people wouldn't be able to find housing and employment and all these other challenges that face you every day. She knew that. The court knew that, and they did it anyway. Just remember that. And by the way, it's a 5-4 decision, which means it wasn't unanimous. Okay, it was not unanimous, but still, it exists. Okay. Internet identifiers, a lot of states now have internet identifiers, right? Well, they didn't exist at the time of Smith versus Doe, and now people are having to do that. We have people in California and many other states who are basically going back to jail because they didn't disclose all their internet identifiers. And I'm like, are you fucking kidding me? If I want to buy a pair of socks on Amazon, I have to tell you what my password is? That's what they want. And I was like, I don't think so. I don't think so. But, you know, you have to make your decision for yourself whether or not you want to take that risk. So you might be wondering, has the U.S. Supreme Court ever made a stupid decision before? The answer is yes. Okay. So one of them that I think about is Plessy versus Ferguson. Okay, and Plessy versus Ferguson, which was issued in 1896, a long time ago, right? But the court's not any smarter today. But anyway, in Plessy versus Ferguson, the U.S. Supreme Court said, separate but equal education, just fine. You don't want to give your students pens, pencils, textbooks? We don't care. I don't know if they had desks and chairs, but Plessy versus Ferguson, it's fine. Well, yeah. So I had this lovely picture here. And we didn't have PowerPoint presentations, okay? But this is a young black woman going to school, a former white school. So anyway, it was overturned. But you know what? It took a long time, 58, years. And that decision, even if you don't know Plessy versus Ferguson, you've probably heard of Brown versus Board of Education, okay? So it took them 58 fucking years to correct their mistake. And I say, I'm not that patient. And by the way, I'm just too old to wait 58 years. So the fact is, we got to do it now. And that's what we're going to be doing tomorrow. And we're going to be educating the court about the impact of the stupid decision that they made. Okay, so I believe in incrementalism, which means drop, Chinese water torture, I don't know. Incrementalism, by the way, my Shiro, RBG, believed in incrementalism. I'm a fan of her and her approach. And so in California, what we've done is we started at the lowest hanging fruit, and we're making our way up the tree. By the way, when you make your way up the tree, the cases get harder. But as I said, it only took 100 cases. We got rid of presence restrictions. We got rid of residency restrictions, right? Halloween and sign requirements. And we're going up the tree. We're also branching out. So right now, our biggest case, and I won't belabor it, is in Missouri. And it has to do with a Halloween sign requirement. If your state has a Halloween sign requirement, let me know, because we want to challenge it there too. Okay, so here we go. Ruth Bader Ginsburg said, real change, enduring change happens one step at a time. One step at a time. We need to overturn this decision. Right. Okay, whoever Frank Sonnenberg is, he says incremental progress leads to long-lasting results. I truly believe that. So think about it. Incremental progress leads to long-lasting results. By the way, RBG, my Shiro, she predicted Roe versus whatever was gonna fail, would be stricken down by the court. And she said they didn't build a strong enough foundation. Folks, we need to build a strong foundation to take Smith versus Doe down, and we're working on it, brick by brick. By the way, in my board meeting last year, we get together once a year face-to-face. Most of the time we're doing virtual meetings. I had the board members play Jenga. Anybody here play Jenga? Okay. Folks, that's what we're doing. We're playing legal Jenga, okay, until the whole tower comes crashing down. Sometimes I compare myself to a termite. I'm a legal termite. You know what? That doesn't hurt my feelings, but I'd rather be called a badass attorney. But the fact is that incrementally, we're working on this. We're chewing at the foundation until the damn thing collapses. So I've given you a lot of news, maybe. It's news. I've given you a lot of information. Now I want to give you some hope. So here goes. At the 50th anniversary of Dr. Martin Luther King Jr.'s presentation of I Have a Dream, I happened to be driving in my car on a long trip, and I heard it. They broadcast the whole thing. And as they were going through that, I went, you know what? That sounds very similar to what's going on in the registrant community. I wonder if I can modify that speech and make a difference. And so I did. So I'm going to read it to you now. But, okay, changing this to the other Janice, what other hat I'm wearing here. Here we go. So I'm happy to join you today in a day of consequence, a day that may go down in history as a turning point in a civil rights movement dedicated to restoring justice for all. In 1787, the founders of our country created and adopted a constitution, which established the United States of America. 4 years later, the founders amended the Constitution by adding protections for individual rights and liberties, 10 amendments now known as the Bill of Rights. But more than 200 years later, the promises of the Constitution and the Bill of Rights are being denied to a group of citizens who languish in the corners of society and find themselves exiled in their own land. That group of individuals has been labeled by some as sex offenders. I shall henceforth refer to them as registered citizens. Many registered citizens have made a mistake. Many have broken a law. All have paid their debt to society by going to jail or prison. But despite the payment of their debt to society, registered citizens continue to be punished by being exiled from some or all members of their families. They also continue to be punished by being denied jobs, a home in which to live, credit, access to parks, beaches, and libraries. Some registered citizens are unemployed, some are homeless, and some are murdered by vigilantes for no other reason than their label. This is punishment, despite what the U.S. Supreme Court has ruled. The requirement to register is not the same as or even similar to becoming a member of Price Club. In a sense, we have come to this conference in Washington, D.C. to cash a check, a promissory note signed by the founders of this nation. It is obvious today that the United States of America has defaulted on this promissory note as far as registered citizens are concerned. Instead of honoring the sacred obligations of the Constitution, the United States has given registered citizens and their families a bad check, a check which has been returned and marked insufficient funds. But we refuse to believe that the Bank of Justice in America is bankrupt. We refuse to believe that there are insufficient funds in the great vault of opportunity of this nation. So we have come to Washington, D.C. to cash this check, a check that will give us the rights and security of justice. We have also come to remind the United States of the need to act now. For it would be unconscionable that the nation overlook the urgency of the moment when civil rights are denied and citizens such as Charles Parker and his wife Gretchen Parker were murdered by vigilantes in South Carolina, as well as Michael Dodley in California. This year of the registered citizens' legitimate discontent will not pass until there is an invigorating year of freedom for registered citizens. 2025 is not an end, but a beginning. Today, there are more than 850,000 American citizens who are being denied their constitutional rights every day, 24 hours a day, 365 days a year. This must stop. Now is the time to lift our nation from the quicksands of injustice to the solid rock of justice. Now is the time to make justice a reality for all citizens. But we cannot move forward alone. Instead, we must include our loved ones, parents, children, nieces, nephews, aunts, uncles, neighbors, and friends who will serve as objective witnesses to the plight of registered citizens. I am mindful that some of you have come from faraway cities such as Springfield, Columbia, Jefferson City, Los Angeles, Miami. I am also mindful that some of you have recently been released from prison and that others are currently on probation or parole. Go back to Springfield, go back to Columbia, go back to LA, go back to Miami, go back to the slums where some homeless registered citizens are forced to reside, knowing that somehow this situation can and will be changed. I say to you, friends, that even though we face the difficulties of today, tomorrow I have a dream. It is a dream deeply rooted in the American dream. I have a dream that one day this nation will rise up and live out for all citizens the true meaning of its creed. We hold these truths to be self-evident, that all people are created equal. I have a dream that one day in the parks of Arizona, registered citizens can enjoy a picnic with their family. I have a dream that one day in the libraries of New Mexico, registered citizens can read a book. I have a dream. I have a dream that one day in the state of Florida, registered citizens will be allowed to enter emergency shelters when a hurricane approaches. I have a dream that one day in the state of Iowa, registered citizens will be able to live with all members of their families. I have a dream. I have a dream that one day in the state of Missouri, registered citizens can celebrate Halloween in their own homes without fear of arrest. I have a dream that one day in the state of Texas, registered citizens can live in any city or any county they wish to live in without the government posting a sign in front of their homes. I have a dream. I have a dream that one day in the state of California, parents can visit their children's schools without fear of arrest. I have a dream. I have a dream that one day in America, registered citizens will no longer be required to wear GPS monitors. I have big dreams here. I have a dream that one day in America, armed police officers will no longer show up on the doorsteps of registered citizens for a compliance check. I have a dream. I have a dream that one day the names, photos, and home addresses of registered citizens will no longer be published on the internet. I have a dream. I have a dream that one day registrants can travel freely to any country they wish for any lawful purpose without fear of being denied entry. And by the way, without a unique identifier on their passport. I have a dream. I have a dream that one day registered citizens will not be treated like lepers and will not be publicly disgraced, humiliated, and shamed. I have a dream that one day in America, registered citizens will not be hunted down and murdered by vigilantes. I have a dream. I have a dream that one day in America, the U.S. Supreme Court will recognize that registration is punishment and prevent new laws from being applied retroactively to registered citizens. I have a dream that one day in America, registered citizens will live in a nation where they will not be judged by a mistake they made decades ago, but by the content of their current character and actions. This is our hope. This is the faith with which we will continue our work to restore justice for registered citizens. With this faith, we will be able to hew out of the mountain of despair a stone of hope. That will be the day we all will be able to sing with a new meaning, "My country, 'tis of thee, sweet land of liberty." And if America is to remain a great nation, this must be true. So let justice ring from Mount Rainier in Washington State. Let justice ring from the Potomac River in Maryland. Let justice ring from the Ozark Mountains in Missouri, and let justice ring from the Mississippi River. Let justice ring. And when these things happen, and they will, justice will ring from every village and hamlet, from every state and city. And that will in turn speed up the day when all citizens, registered and unregistered, join hands and repeat together the ultimate goal of this movement, which is to live as citizens, as expressed clearly in the last 6 words of our nation's Pledge of Allegiance, with liberty and justice for all. Thank you.